Principal distance in the sense, number one, we will protect all religions equally. Protect all religions equally in the sense, if there is Kailash Mansarovar Yatra, we will fund that yatra. We will give free tickets to the people, go to that yatra. And if there are people going on a Hajj pilgrimage, we will subsidize them as well. Although that subsidy has now been removed, but there was a time when the subsidy was given for the Hajj as well. Equal protection of the religion in the sense, we will give donation for the construction of a mosque as well, for the construction of a gurdwara as well, for the construction of a temple as well. We will equally protect all religions. And no religion will be a state religion. And secularism also in India is unique. Unique in the sense that we have political parties in the name of religion. Akali Dal, All India Ittihadul Muslimin, or Majlis-e Ittihadul Muslimin of Mr. Owaisi. We had Hindu Mahasabha. We had the Christian parties. That means India is unique. Just like India, because religion is so much intimately associated with the lives of the Indians that you can't take religion out of India or religion out of the psyche of Indians. That is why the constitution maker said we will have a different form of secularism. And what is that different form of secularism? We will equally protect all religions. And at the same time, we will not uphold any religion as the state religion. And at the same time, we will ensure that there is no discrimination. On the grounds of religion. For example, Article 15 of the Constitution, which we will discuss next week, it categorically states that the state shall not discriminate anybody on the grounds of religion. Article 16, for example, it says there shall be equality of opportunity in public employment. When UPSC advertises posts, announces jobs of the civil services examination, there is no discrimination on the grounds of religion. It's not that only Hindus and Muslims can participate, Sikhs and Christians cannot. Anybody can participate regardless of your religion. Article 27, which says the taxes that you and me pay cannot be used for the promotion of a particular religion. For example, what would happen during the time of Aurangzeb or even prior to Emperor Akbar, because Akbar abolished it later, jizya. It was a tax primarily on non-Muslims. So if the Mughal Empire wants to protect you, protect your property, you have to pay tax. Such form of jizya cannot be imposed in India. That the state will protect you if the Muslims will pay this tax, if the Christians will pay this tax, if the Buddhists will pay this tax, if the Sikhs will pay this tax. No, that cannot happen because that is prohibited by Article 27. And all these important articles, they uphold the concept of secularism in India, that there is no discrimination on the grounds of religion. That is secularism in India. So what is the nature of the Indian state? Sovereign. You know that. What's the meaning of sovereign? Socialist, secular, democratic, republic. But when we look at this term secularism, in GS paper 2, in polity, we have to just look at the legal aspect of secularism. Then there is a social aspect of secularism. That is something that we will be discussing in GS paper 1, where we will talk about social issues. So secularism, for example, some people say is under assault in India. Why? Because we see majoritarianism emerging in India. When the Prime Minister is openly conducting the puja, when the new parliament complex is to be inaugurated, is that not upholding or promoting one particular religion at the expense of others? When the Rafale jet is to be inducted into the Indian Air Force, the defense minister performs the puja, which is a Hindu ritual. Is that not promoting one particular religion at the expense of others? The rise of majoritarianism and its impact on secularism, that will be the subject matter of GS paper 1, where we'll have to discuss social issues. For example, communalism, regionalism, secularism, society of India, so on and so forth. In GS paper 2, I just have to tell you what is secularism from the legal perspective in India. And that is, the state will not uphold any religion as its state religion. The state will equally protect every religion, and there will be no discrimination on the grounds of religion. So Article 15 makes it clear that the state shall not discriminate only on the grounds of religion. Article 16 makes it clear that all public employment, there should be no discrimination on the grounds of religion. Article 27 makes it clear that there can be no tax specifically for the promotion of a particular religion. All these things make it abundantly clear that what we follow is secularism. And was India secular before 1976? Yes. But before 1976, secularism was implicit in India. Implicit in the sense, although these articles did not say that we are a secular state, but these articles meant that we are a secular state, where there is no discrimination on the grounds of religion. But what was implicit till 1976 became explicit in 1976. That's the only difference. Clear? 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 Shiva Kumar, what's your question, please? NCRTs of 6th and 10th, not important? Not important. Explicit in 1976 because we mentioned it in the constitution that we are secular. That means we became explicit. We openly declared it. Otherwise, previously it was implicit. It was hidden. Secular word was not there, but the idea of secularism was there already. Okay. Now we will look at the last theme that we have to cover from the preamble, which is what are the objectives of the preamble, objectives of the constitution as mentioned in the preamble. And the first objective is justice. And what sort of justice? Justice in the sense, give dignified treatment to everybody. And what is that dignified treatment? There should be justice in social sphere, in economic sphere, in political sphere. Social justice, for example, there was a time, or when we look at, some people say that in Rig Ved, there is Purusha Sukta hymn, which talks about Chatur Varna system. Varna system in the sense Brahmins, Kshatriyas, Shudras, Vaishyas. There are experts who say that this was a Varna system. This was some sort of division of labor. Division of labor in the sense, in an organization, there, let's say in our organization, there are teachers. There are those who write the content. There are those who support us operationally. That doesn't mean one is inferior or the other is superior. It only means division of labor. Eat as well. Mind is division of labor in the sense, hands are used to slap, to eat as well. Mind is used to think. Eyes are used to see. That doesn't mean eye is superior to heart or mind is superior to mind is superior to heart, and so on and so on. Every organ is important. It's just division of labor. So just like in that society, there was division of labor, a Varna system. That is why Mahatma Gandhi was in favor of Varna system. That is the disagreement that Dr. Ambedkar had with Mahatma Gandhi. Mahatma Gandhi was in favor of the Varna system, that there has to be a division of labor in the society. Everybody cannot become a doctor. Some have to be teachers as well. Everybody cannot become a teacher. Some should be there to support others as well, participate in trade. There should be others who will clean the roads as well, whether dry cleaning or manual cleaning, whatever it is, but we need people to clean the roads as well, or we need machines for that. So there has to be division of labor in the society. And that is how those who would teach, those who would do the philosophical work, they were the Brahmins, or they were called Brahmins. Those who would be participating in wars, defending the territory, they would be called Kshatriyas. Those who would participate in the trade activities would be called the Vaishyas. And those who would do the menial jobs, who would support the other three Varnas, they would be called Shudras. But this was division of labor. And then this division of labor became division by birth. So a child born to a Brahmin remained a Brahmin. Child born to a Shudra remained a Shudra. And a Shudra can never become a Brahmin. A Shudra can never take education and become the preacher or the educationist or the teacher. Cannot even read Sanskrit. Then it became discriminatory. And it became discriminatory to such a level that if I was a Dalit, I would walk on the road, I would see the Brahmin coming from the other side or an upper caste coming from the other side, I would jump in the mud because my stench would cause pollution to the member of the upper caste. And that is why some people said, some experts say that this entire discrimination was based on these twin concepts of purity and pollution. The dress, the food habits, the drinking habits of the Brahmins are pure. The dress, the food habits, the drinking habits of the Dalits is impure, polluted. So if I'm a Dalit, I would see the member of the upper caste coming from the other side. Even my shadow would cause pollution to them. I would jump in the mud. I cannot spit on the floor. I had to carry a pot around my neck and spit in that pot. I cannot drink from the well, which is meant for the upper castes. I cannot even take cooked food from them. Dr. Ambedkar, who was a Dalit himself, for days he could not drink water in the school. Why? Because the well from which he was allowed to drink water, it was dry. And the other well, which was full of water, he could not drink water from that because that was meant for the upper castes. That was a society. And if that society continues even after independence, then what is the need for independence? If such a society, such a discrimination continues even after independence, then what is the need for this beautiful document called the Constitution? Constitution said in its preamble that our first and the foremost objective is social justice. And that social justice where there will be no discrimination on the grounds of caste, where there will be no discrimination based on these so-called concepts of purity and pollution. This individual is a manual scavenger. Scavenger in the sense, there are our septic tanks, manholes. These men, they enter the manholes because we need to manually clean them. They enter into these manholes. These manholes are full of dirt. They eject poisonous gases without any security gear, without any helmet, without any mask, without any gloves, without the protective gear. They enter into these manholes and they inject these poisonous gases and then they die. And all these manual scavengers, these are the members of the Dalit community. Why? Because what was meant to be division of labor became division by birth. That means these members of the Dalits, they will always clean this dirt. Despite ending the menace of manual scavenging, deaths continue. So there is a clash between constitutional objective and the empirical reality. Constitutional objective is we will implement social justice, but the reality is justice is too far even now. But we will discuss that over a period of time. But first we need to understand what is social justice. Justice for all in social sphere without any discrimination on the grounds of caste or sex. That is the objective of the Constitution. Clear? Let's take a break. It's 7:50. We will meet at 8:05 a.m. See you on the other side of the break. four themes in the preamble. The fourth one, what are the objectives of the Constitution? What are the objectives that we want to achieve through this Constitution? The first is social justice. Second, political justice. What is this political justice? United States of America is considered to be a very progressive society, a liberal society. They've never had a woman president. Hillary Clinton came close to becoming the president of the United States, but was defeated by Donald Trump. They gave voting rights to women very late. Even Britain gave voting rights to women in the 1920s. Even Switzerland gave voting rights to women in 1970s. But India started with this experiment that there should be no discrimination between man and a man or a man and a woman in political sphere. In one single step, in 1950, voting rights were given to all, regardless of their gender, regardless of their age, regardless of their language, regardless of their religion, regardless of their caste. So there was a time when voting rights were given only to those who had property during the colonial period. There was a time when voting rights were given only to the educated class. But in 1950, when the Constitution was enacted, voting rights were given to all. Yes, there was an age limit. Somebody who is an Indian should be above the age of 21 in order to vote in the elections. Later on, this voting age was reduced to 18. There is an age which you have to achieve after which you can contest elections. For example, you should be 25 years in order to contest elections to Lok Sabha or Legislative Assembly. But beyond that, there is no other discrimination. No matter what religion you come from, what caste you come from, what language you speak, what gender you possess, there is no discrimination whatsoever. And that is what we call political justice. Universal adult franchise. Anybody who is an Indian and is above the age of 18 has the right to vote, the right to contest elections. And one classic example of this is Lily Thomas versus Union of India, 2013. What is that case? We have a law known as Representation of the People Act 1951. Listen to me carefully. When we will discuss elections, we will discuss this law in great detail, Representation of the People Act 1951. It is this law which governs the conduct of elections in India, whether elections to Lok Sabha, elections to the state legislatures. And there used to be a section 8, clause 4 of the Representation of the People Act 1951. And what it did, it created a classification. Classification in the sense, ordinary citizen and a legislator. Who is an ordinary citizen? You, me, others. We are not part of the legislature. We are not MLAs. We are not MLCs. We are not MPs of Lok Sabha, Rajya Sabha. Sorry. If, for example, we have committed a crime for which we have been sentenced to 2 or more years in jail, we are disqualified from contesting elections. We cannot contest elections, which means you and me, we are not legislators, we are not members of the parliament, we are not members of the state legislatures. If we have committed a crime for which the court has sentenced us to 2 or more years in jail, we cannot contest elections. We are disqualified from contesting the election. But if there is a legislator, now let's assume I am a legislator, I am a member of the parliament or a member of the state legislature. I have committed a crime for which the court has sentenced me to 2 or more years in jail. I am not disqualified. I can still continue as a lawmaker. I can still continue as a legislator. And I have 3 months. Within 3 months, I have to appeal to a higher court. For example, the district court has said, you are guilty, you are sentenced to 2 or more years in jail. I am a legislator. I will not be disqualified. What I have to do, I have 3 months. Within 3 months, I have to approach the high court. If the high court says, no, this sentence is set aside, I will continue as a legislator. If the High Court also says, no, you are guilty, you are sentenced to 2 or more years in jail, even then I am not disqualified. What I have to do, I have to approach Supreme Court within 3 months. And only when the Supreme Court says you are guilty and you are sentenced to 2 or more years in jail, I will be disqualified. That means this section 8 clause 4, what it does, it creates a classification. An ordinary citizen, if you have committed a crime for which 2 or more years punishment is given to you, you are disqualified from contesting the election. But if you are a legislator, you are not disqualified. Instead, you are given 3 months window to appeal to a High Court. Instead, you are given 3 months window to appeal before the Supreme Court. Matter went to the court. Lily Thomas versus Union of India. Lily Thomas argued before the Supreme Court, my lord, the objective of the Constitution is political justice. Court said yes. My lord, political justice means there should be absence of any arbitrary distinction between man and a man in political affair. What is this arbitrary distinction? Without any logic. What is arbitrary distinction? For example, all the students who are attending this class right now, if I were to say that those who attended this class, joined this class at 6 a.m. till 7 a.m., you cannot ask me any question. But those who joined between 7 to 8, they can ask me 10 questions. And those who join after 8, again, they cannot ask me any questions. This is arbitrary distinction without any logic. What is the logic? To say that those who joined the class right on time, they cannot ask me questions. And those who joined the class midway, they can ask me 10 questions. What is the logic behind this? What is the rationale behind this? What is the thought process behind this? This is illogical. This is arbitrary. Can I still create a distinction? Yes. Can I still create a distinction which is not arbitrary, which is not illogical? Yes, I can. How? If you are from law background, you can ask me only one question. Because you know the law, you may have a doubt here and there, you can ask me one question. But if you are from a science background, or if you are from engineering background, you can ask me 10 questions. I'm creating classification. I'm classifying students. I'm discriminating students, but on some logical grounds, on some valid grounds, on some genuine grounds. Because those who need more protection, those who need more guidance, I will give them more opportunity to ask me questions. This is logical. Lily Thomas argued that this distinction, where you are discriminating between an ordinary citizen and a legislator, both have committed crime. One cannot contest elections, other can contest elections and continue as a lawmaker. This goes against the principal philosophy of the Constitution, which is political justice, the idea of political justice. Supreme Court said, you're absolutely right. This section 8 clause 4 is unconstitutional. Why unconstitutional? Because it creates an arbitrary, illogical distinction between man and a man in a political affair. Now, the moment you are convicted by the court of law, for which you are sentenced to 2 or more years in jail, on the date of your conviction, you will be disqualified. Shri Rahul Gandhi was convicted by a court in Gujarat for defamation, criminal defamation. On the date of his conviction, he was disqualified. Yes, then he approached the High Court. High Court said, no, you are guilty, remained disqualified. Then he approached the Supreme Court. Supreme Court said, yes, we will hear this case. Till that time, you can continue as the lawmaker. That means only after the intervention by the court. Otherwise, on the date of your conviction, you are disqualified. Today's newspaper, when you will read a member of parliament from Lakshadweep, who belongs to the NCP, Nationalist Congress Party, he has been disqualified by Lok Sabha because he was convicted by the court of law for some offense for which he was given 10 years in jail. And now he has been disqualified from Lok Sabha. We will discuss his case again when we will discuss the Representation of the People Act. But the point is, preamble tells us the fourth theme that it talks about is what are the objectives of the Constitution. One objective is justice. Justice, social justice, political justice, and economic justice. What is economic justice? There are people who may not be able to get a job, get livelihood opportunities. Why? Because they belong to poor sections of the society. They don't have means for education. Should we leave them to the mercy of God? Or should we give them scholarships? Should we give them pensions? Should we give them wages under Mahatma Gandhi National Rural Employment Guarantee Act, MG Narega? Economic justice. During COVID-19 lockdown, when millions lost their lives, when there was a threat to the small entrepreneur, loans were given at cheap rates to these MSME sector, medium, small, and micro enterprises. That is economic justice. Economic justice means those who are old age pension should be given to them. Those who cannot afford insurance, free insurance is provided to them. The state will not turn a blind eye to those who are from marginalized, weaker sections of the society. That is economic justice. So that we can improve the standard of living of the people, so that we can make the life meaningful for all the members of our society. That is justice. That is economic justice. And that is another objective of the Constitution. Another objective is liberty. What is liberty? Freedom. Freedom of thought, freedom of expression, freedom of belief, faith, and worship. That's another idea of a secular state. We will not force you to follow one particular religion. You are free to choose a religion of your choice. You have that liberty, you have that freedom to think whatever you want to think. Write a book, write a novel, make a song, make a movie, draw a cartoon. Whatever you want to believe in, you have that liberty, you have that freedom. That's another objective of the Constitution. Liberty, freedom of thought, belief, faith, worship. You can worship your God. That's another objective of the Constitution. And there has to be equality. Equality in all sphere. We will not discriminate on the grounds of religion, race, caste, sex, place of birth. There should be no inequality in the society. Complete equality, that's the goal. Fraternity. We are a land of diversity. You travel 50 kilometers, you will see another language being spoken. If not another language, at least another dialect used by the people. Diversity is religious. Hindus, Christians, Muslims, Sikhs, Jains, Parsis, Buddhists, atheists. Different set of people. Diversity is caste. People of different castes. Diversity is there are different tribes. Diversity is different languages being spoken. Diversity is food diversity. Diversity is the clothing that you use. There is so much diversity in this country. From north to south, from east to west, in the central part of India, so much diversity. Yet we are united by oneness. And that oneness is the idea that we are all Indians. How can we implement a sense of brotherhood amongst all the members of our society, despite the fact that we are diverse in our languages, in our religion, in our caste, in our tribal character, in our food, in the way we dress ourselves? There is so much diversity, yet we are united. And we have to ensure, Constitution has to ensure that we have that feeling that we are the children of the same soil, we are from the same motherland. That is why Constitution says you can travel freely throughout the territory of India. That is why the Constitution says you can reside and settle anywhere within the territory of India. That is why there is no ban on the migration of people from one part of the country to another part of the country. Because we are the children of the same soil, we belong to the same motherland, we are united by the Indianness. And all of these three things, liberty, equality, fraternity, this was the slogan of the French Revolution. And we have incorporated this from the French Revolution into our Constitution. That means our objective is not just justice, social justice, economic justice, political justice. Our objective is liberty, equality, fraternity. And it is through this fraternity that we will ensure dignity of an individual. Everybody should be given a dignified life. And it is through this that we will ensure unity and integrity of India. Integrity of India, listen to me carefully, because this word also was added by the 42nd Constitutional Amendment Act 1976. Unity means we are united by the sense that we belong to one soil, common motherland, India. We are united. United despite the fact that we are diverse. That is what we call unity in diversity. tolerance is the second name for this. You may speak a different language, I will speak a different language, yet we are united because we are Indians. You are from a different religion, different caste, different tribe, different dress sense, but we are still different, yet we are united because we are Indians. And unity and integrity. Integrity is very important. Why? Because there was a time there are still times when there are secessionist tendencies. For example, Khalistani movement, as is in the news recently. There was a movement in Punjab where some members of the Sikh community wanted to come out of India, establish a different country for Sikhs known as Khalistan. So it was a secessionist movement. That means you want to secede, you want to come out of India, establish a new country known as Khalistan. Secessionist movement in Jammu and Kashmir. Some section of Jammu and Kashmir want to come out of the Union of India and create a different country, Jammu and Kashmir. Secessionist movement in Nagaland. Secessionist movement in Manipur. Secessionist movement in Arunachal and in some other parts of Northeast. It was at this time that the Prime Minister of that day, Srimati Indira Gandhi, and the Parliament decided that we need to ensure that the country is integrated together. Integrated together, there should be no opportunity to secessionist tendencies. We have to ensure that this entire country remains the way it is. No part of this territory should come out of the Union of India. That means this entire country should be an integral whole. One part should not come out of the Union of India. And that is the objective of the Constitution. We have to ensure dignity of an individual. We have to ensure that the people of this country remain united, unity. And at the same time, the territory of India that we have, that should also remain the way it is. It should not, one part of the territory should not come out of the Union of India. That means we have to ensure the integrity of India. It has to remain the way it is. All these are the objectives mentioned in the preamble. These are the objectives that we want to achieve, obtain through this Constitution. That is preamble. Now, is preamble part of the Constitution or not? Normally, when we say that book starts with chapter 1, preface is not part of the book. The real book starts with chapter 1. In the same fashion, is preamble part of the Constitution or not? In Berubari Union, 1960, Supreme Court said no, preamble is not part of the Constitution. In 1973, in Keshavananda Bharati case, Supreme Court said yes, preamble is part of the Constitution. And same thing was reiterated by the Supreme Court in the LIC case. Life Insurance Corporation of India case. But why this difference? 1960 Supreme Court saying preamble is not part of the Constitution. A decade later, Supreme Court saying preamble is part of the Constitution. Reiterating again in 1996 in LIC case that preamble is part of the Constitution. Why this difference? Listen to me carefully. In Berubari Union case, the Supreme Court thought that preamble is the philosophy of the Constitution. And preamble is basically not enforceable in any court of law. Not enforceable in a court of law means, for example, fundamental rights, which we will discuss next week. Those are enforceable in a court of law. Enforceable in the sense that if my right to equality has been violated, freedom of speech and expression is violated, right to life is violated, these are my fundamental rights, I can approach the court and the court will protect my fundamental rights. If I'm illegally detained by the police, the court will set me free. If my book has been illegally banned by the government, the court may see that if this book is not a threat, we can order the publication of this book, the selling of this book. So the fundamental rights are enforceable in a court of law. In a sense, if your fundamental rights are violated, you can approach the court. The court will protect, safeguard, and uphold your fundamental rights. But preamble is not enforceable in a court of law. In itself, preamble is not enforceable in a court of law. What does that mean? Preamble is the philosophy. How can we say and tell the court that dignity is not ensured? How can we tell the court that unity and diversity is not maintained? Because these are philosophies. These are objectives. This is the nature of the Indian state. Preamble already tells us what this book is all about. Book is enforceable. Preamble tells us what is the thought process which was going on in the minds of those who drafted this constitution. But this constitution is enforceable. If constitution is violated, you can go to the court. But preamble is just like the philosophy, just like a document, which tells us what this constitution is all about. So in itself, it is not enforceable. You can't go to the court and tell the court that preamble is not being followed, because it's a philosophy. Yeah, constitution, if it is not followed, then you can go to the court. Same logic was used by the Supreme Court. Supreme Court said if preamble is like the identity card of the constitution, if the preamble is like the philosophy of the constitution, if the preamble is like the preface of the constitution, constitution is enforceable, preamble is not. But later on in Keshavananda Bharti case, Supreme Court said no, preamble is part of the constitution. Why? Because in this case, the government lawyer told the Supreme Court, my lord, do you know how constitution was adopted? Supreme Court said yes. How the constitution was adopted? Please tell us. The government advocate said that one by one, every article of the constitution was discussed and put to vote. So, okay, should we have right to life or not? What should be the wording of this? There was a thorough discussion in the Constituent Assembly, and then there was voting. Only when the majority people said yes, right to life should be a fundamental right, right to life became part of the constitution. That means one by one, every article, every part of the constitution was thoroughly discussed and then voted upon, and then it became part of the constitution. Sir, okay. Sir, in the similar fashion, preamble was also discussed. Preamble was also voted upon. In fact, preamble was the last item to be added to the constitution. Preamble was also discussed. Preamble was also thoroughly discussed. It was voted upon by the Constituent Assembly. In fact, it was the last item voted in the Constituent Assembly. Then preamble became part of the constitution. So just like any other part of the constitution was debated, thoroughly discussed, then voted upon, in the same fashion, preamble was also discussed, thoroughly debated, voted, and then it became part of the constitution. Supreme Court said, if this is true, then preamble is part of the constitution. And if it is part of the constitution, which means it can be amended as well, because only constitution can be amended. And if preamble is part of the constitution, then constitution can be amended. Then preamble can be amended. Sir, but sir, I have a confusion. Sir, what is that confusion? Sir, you said preamble is based on the objectives resolution of Pandit Nehru, which was introduced by Pandit Nehru in the Constituent Assembly and adopted by the Constituent Assembly on January 22, 1947. Yes. And now you are saying preamble was the last item added to the constitution. That means in 1949. Isn't there a discrepancy? No. Objectives resolution is not preamble. Preamble is based on objectives resolution. So the wording of the preamble was changed here and there based on objectives resolution, but objectives resolution is separate. Preamble is separate. Objectives resolution was adopted on 22nd January 1947. Preamble was the last item to be voted upon. So there's a difference. Okay, sir, this much is understood, but why was the preamble last item added to the constitution? Why wasn't it the first or in the middle way? Why was it the last item? Imagine a situation. We have the entire constitution, Article 1 onwards, and then we have the preamble. Listen to me carefully. What is preamble? Philosophy of the constitution. What is preamble? Without looking at the constitution, if you want to know what is the crux of this constitution, for that you have to go through the preamble. Preamble is the identity card of the constitution. Constituent Assembly, the makers of our constitution, thought that first we will draft the entire constitution, write the entire constitution, adopt the entire constitution, and then see if there are some things mentioned in the constitution which go against the preamble. Then we can remove them. To ensure that the entire constitution is in agreement, is in conformity with the preamble. That is why preamble was the last item to be voted upon in the Constituent Assembly. And since preamble was also discussed, voted upon, just like any other article of the Constitution was discussed and voted upon, Supreme Court said in Keshavananda Bharti case, then in the LIC case, that preamble is part of the Constitution. And when it is part of the Constitution, it can be amended as well. Let's look at some of the quick points which can be relevant for your prelims examination. US Constitution was the first one to begin with the preamble. Just like Indian Constitution, US Constitution also begins with "We the people of the United States of America." Preamble is part of the basic structure of Indian Constitution. Or to put it simply, or to put it better, preamble contains basic structure. Yesterday I told you that there is something known as basic structure. Supreme Court in Keshavananda Bharti case said Parliament has the power to amend the Constitution. Parliament has the power to amend any provision of the Constitution. But Parliament does not have the power to alter what it calls basic structure. No amendment of the Constitution can violate basic structure. And the preamble contains basic structure. How? What does preamble talk about? We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. Is preamble part of the Constitution? Yes. That means, can preamble be amended by the Parliament? Yes. But can Parliament change the basic structure? No. That means, can tomorrow Parliament say, we are not sovereign? We will remove this term sovereign from the preamble. No, you can't do that, because sovereign is part of the basic structure of the Constitution. Can tomorrow Parliament say, we will drop this word secular from the preamble? No, you can't do that. Why? Because secularism is part of the basic structure of the Constitution. Can tomorrow Parliament say, we want to change republic into monarchy? We will be a constitutional monarchy instead of a constitutional republic. No, you can't change that, because this is part of the basic structure of the Constitution. But sir, the word socialist and secular was added to preamble in 1976. Does it not violate basic structure? No, it does not. Why? Because you can always, what you can always do, you can enrich preamble. Enrich preamble in the sense, you can add more objectives to the preamble. You can add more nature to the preamble if it is not incompatible with already that is there in the preamble. How? For example, Constitution said in its preamble that we, the people of India, having solemnly resolved to constitute India into a sovereign, democratic republic. These were the only three things mentioned. That means you can't change sovereignty, delete sovereignty. You can't delete democratic. You can't say we will become a dictatorship. You can't change republic, because you can't say we can become a monarchy. But can you enhance this nature of Indian state? Yes. Add secular. Is secular incompatible with democracy? No. Is secular incompatible with republic? No. Is secular incompatible with sovereignty? No. But can you say secular and at the same time Hindu Rashtra or Islamic State? That would be incompatible with the idea of secularism, because secularism means you can't proclaim any religion as the state religion. So by calling this country an Islamic State or a Hindu Rashtra or a Khalistan, you're basically violating secularism. That is not allowed. You can add more objectives, you can add more nature. If it is not incompatible to whatever is already present in the preamble, that you can do, because preamble contains basic structure. And basic structure is something that no amendment of the Constitution can violate. So is preamble part of the Constitution? Yes. US Constitution was the first to begin with the preamble. Preamble contains basic structure, which means you cannot delete anything from the preamble. You can add more things to the preamble without altering the existing things. Preamble aids the legal interpretation of the Constitution when the language is found to be ambiguous. And what is that ambiguity? Aadhaar. A unique 12-digit identification number. All of us have Aadhaar, a unique 12-digit identification number. What makes Aadhaar unique? We give our fingerprint, we give our iris scan. Fingerprint, iris scan of every individual is different. That means every individual's Aadhaar is different. That means it is a unique document. When you give your fingerprint, when you give your iris scan, you also part away with your privacy. How do you part away with your privacy? Listen to me carefully. There are different databases. What is a database? A software, for example, where information is stored. One example of a database is Microsoft Excel, for example. It's a database where your information is stored. Information is stored in different databases. What is that information? For example, this is the database where my medical records are stored. I go to Manipal Hospital, I perform some tests, I meet a doctor. All this is recorded and it is stored on the servers of Manipal Hospital, stored in this database. Clear? This is where my bank records are stored. I have an account with the ICICI, they have my records. This is where my insurance records are stored. This is where my driving license is stored. This is where my SIM card information is stored. I'm a subscriber of Airtel, India's largest cellular network after Jio, JGO. Whatever information, SIM card information, who I call, what is the message, everything is stored here. But these are in different databases. They are in different silos separately. Is there a possibility that we can link all this information together? Is there a possibility? If you're a student of computer science, you would know that there is something known as primary key. This primary key can become Aadhaar. Key in the sense, if you gave your Aadhaar number while in your driving license, while taking a SIM card, while booking an appointment with a doctor, while submitting your bank details or opening a bank account, while opening an insurance claim, if in all these instances you are giving your Aadhaar, Aadhaar becomes your primary key. That means you can link all the databases together. And who will monitor you? Government. Because right now the information is stored separately. But if Aadhaar is one common thread in all these databases, then your life becomes as transparent to the government as a contact lens. The government will get to know who are you calling, what are you speaking, where are you traveling. You are booking a ticket on an airline portal. Where are you traveling? What is the bank transaction that you do? Everything becomes transparent to you. And this violates privacy. Because now you are naked in front of the state. The state knows each and every activity of yours. Matter went to the court. K.S. Puttaswamy, who was a former judge of the Karnataka High Court, he filed a case challenging the validity of Aadhaar, saying Aadhaar violates privacy because it can do all these things. Your life becomes as transparent to the government as contact lens. Hence, Aadhaar is unconstitutional. When the matter came to the Supreme Court, the government took a different position altogether because it was challenging the government. The government said there is no such thing as right to privacy. Right to privacy is not a fundamental right. And the government was right. Right to privacy is not mentioned anywhere in the Constitution. Yes, Article 21, it talks about right to life and personal liberty. But it does not talk about right to privacy. Now, 9 judges of the Supreme Court had to first decide this very simple question as to whether right to privacy is a fundamental right or not. But right to privacy is not mentioned anywhere in the Constitution. What is the philosophy of the Constitution? Preamble. What is the utility of the preamble? Preamble is not enforceable in any court of law. I told you. In itself, it is not enforceable in a court of law, but Constitution is. But preamble can be used to interpret the Constitution when there is some ambiguity. Supreme Court said right to privacy is indeed a fundamental right under Article 21 of the Constitution. The Supreme Court was asked, how can you say right to privacy is a fundamental right? Supreme Court said, look at preamble. One of the objectives of the Constitution mentioned in the preamble is that we have to assure dignity of an individual. This dignity gets snatched if there is no privacy. Who am I talking to? Who am I making love to? What am I eating? What am I drinking? That's not the business of the state. Who said this? Supreme Court. But if there is no right to privacy as a fundamental right, that means the state can peep into your bedroom. Because there is no right to privacy as a fundamental right. State can do anything. And if the state is allowed to peep into your bedroom, what will happen to your dignity? Your dignity is gone. But the objective of the Constitution mentioned in the preamble is that we have to assure the dignity of an individual. And this dignity would not be possible unless and until we have the right to privacy. That is why right to privacy is a fundamental right. And Supreme Court was able to do this because preamble has a significance. It is used to interpret when the language is ambiguous. Preamble further. If any power is not given in the Constitution, preamble cannot provide. If any power is not stopped in the Constitution, preamble cannot stop. What does that mean? Is power given to the government or parliament that you can convert democracy into dictatorship? Is this power given to the parliament by the Constitution? No. Can we say preamble gives this power because preamble talks about sovereignty? We, the people of India, having solemnly resolved to constitute India into a sovereign. So I can take any decision, I can unmake any decision, but not this decision. Because you can't convert democracy into dictatorship. If this power is not given to you, preamble cannot provide you this power. Does Constitution stop you from reasonable classification? If Constitution does not stop, preamble cannot stop. Sir, what is that reasonable classification? One objective which is mentioned in the Constitution is equality. What is equality? No discrimination whatsoever. Every single Indian is to be treated alike. But imagine a situation where there are SCs, STs, OBCs, economically weaker sections of the society. They are different from the aspirants belonging to the general category. SCs, STs, OBCs, economically weaker sections of the society, they are different from the members of the general category. So the state has classified people into two groups. Those who require reservation, those who don't need reservation. So although the Constitution in its preamble talks about equality, but it does not stop the state from reasonable classification. This classification is not unreasonable. Why? Because throughout the history, members of the SC/ST community have been discriminated. They were denied educational opportunities, job opportunities. But now in the independent India, we have to uplift them. We have to give them more protection. We have to give them reservations so that they can lift themselves. So the state is classifying people, reasonably classifying people, into those who require reservation, into those who do not require reservation. Does Constitution stop Parliament from making this reasonable classification? No. That means preamble cannot stop. Because preamble, it's not enforceable in a court of law. It's the identity card of the Constitution. It's the philosophy of the Constitution. The best use of the preamble is, it is used to interpret the provisions of the Constitution when the language is found to be ambiguous. If there is some power which is given to the Parliament, if there is a power which is not given in the Constitution, preamble cannot provide that power. If there is a power which is not stopped in the Constitution, preamble cannot stop. That completes our discussion of preamble. Any questions, let me know. Then we will jump to part 1 of the Constitution. How can we say that preamble is not enforceable in nature? Because articles like 15, 16 promote equality, and this equality is mentioned in preamble. If articles 15 and 16 are enforceable, then indirectly preamble is also enforceable, isn't it? No. Preamble in itself is not enforceable. But the Constitution is enforceable. Constitution talks about articles 15 and 16. So those articles are enforceable, not the preamble. Can a person who got released from prison after 10 years contest elections? If I'm sentenced to jail for 10 years, during these 10 years, I cannot contest election. Once I'm released, after my release, for another 6 years, I cannot contest elections. After my release, once 6 years is over, then I can contest elections. Ultimately, right to privacy is part of Article 21. Yes. Can Parliament repeal the Constitution? No. Parliament is created by the Constitution. So how can a body which is created by the Constitution repeal the Constitution itself? That cannot happen. Preamble reflects the principles of the Constitution and thus can be called the spirit of the Constitution. Yes. Does secularism stop officials from practicing their personal religious beliefs? Absolutely not. Can anyone vote after coming from prison? Yes. Sir, the preamble is amended. Yes, amended once in 1976. Persons lodged in jails cannot vote. No. Can preamble be removed? Simple thing, my dear. Preamble contains basic structure. Basic structure cannot be removed, so preamble cannot be removed. Preamble is part of the Constitution. Does that mean preamble also is enforceable? Preamble is part of the Constitution in a sense that preamble can be amended to enrich it, but that doesn't mean it is enforceable because philosophies cannot be enforced. Okay. Let's look at part 1 of the Constitution, Union and its territory. And here we will have to discuss Articles 1 to 4. But you don't have to remember the article numbers, just understand the concept. You don't have to remember what is Article 1, 2, 3, 4, so on and so forth. Just understand the concept. Article Part 1 of the Constitution talks about Union and its territory. Union, the central government, and its territory. Or should we say, what is the territorial strength of India? As of now, we have 28 states and we have 8 union territories. Union territories will be discussed separately when we will talk about this chapter, Union territories. Here we will focus on states. Clear? Why? Because we can't complete anything in single go. We have to look at things one by one. We'll discuss union and its territory now. Union territory, we will discuss separately in a separate chapter called Union territory. When the Constitution was being debated, was being drafted, there was a thorough discussion on what should be the name of this country. Article 1 says, India, that is Bharat, shall be a union of states. First, we will look at India, that is Bharat. Then we will look at what is this term, phrase known as the Union of States. When the Constituent Assembly was meeting, debating, discussing, there was also a question on nomenclature. What should we be? What should we name this newly independent country? Some said, let's stick to India, because that is how we are known world over. Let's stick to India. Others said India is the name given to us by the colonizers. So we should not call this country India, because we have now come out of colonialism. We should stick to this name Bharat, because Bharat is the ancient name of India. Others said, why Bharat? Why not Hindustan? They said, no, Hindustan is the name given to us by the Persians and the Arabs. So we should not call this country Hindustan. Others, they were deeply influenced by USSR, Union of Soviet Socialist Republics. They said we should name this country in a similar fashion. We should call this country Union of Socialist States of India, or Union of Socialist Secular States of India. So there was a lot of debate on what should be the nomenclature, what should be the name of this country. Others said we should call this country Jamudvip. the land of the Jambu tree. That's how we were known in the past as well. But ultimately, a compromise was reached so that modernity and tradition can go hand in hand, so that those who believed in the modern name and those who believed in the ancient name, they can be reconciled together. And that is why Article 1 of the Constitution, which talks about the name of this country, calls it India, that is Bharat. That means both the names are correct. That means both the names can be interchangeably used. India, that is Bharat. Originally, the Constitution was in Hindi as well as English. That means we had the Hindi copy of the Constitution, we had the English copy of the Constitution as well. But over a period of time, Constitution got amended. More articles got added, some articles got deleted, some schedules got added, some parts got added. Now the question before the government was, all these amendments should be made in the Hindi version as well. And this Hindi amended version of the Constitution should have the same status as that of the English Constitution. Ultimately, Constitution was amended, and the Hindi translation of the Constitution was also given the same status as that of the English Constitution. And there, Hindi Constitution says, Bharat, Athat, India. That means in the English version of the Constitution, primacy is given to the English word, India, that is Bharat. But in the Hindi version of the Constitution, primacy is given to the Hindi word, Bharat, or Sanskrit word, Bharat, Atharth, which means India. That means it doesn't matter whether you call this country India or Bharat, both are the names of this country. In fact, there was a petition filed by somebody from Madhya Pradesh in the Supreme Court. My lord, I have a petition, public interest litigation. And we will discuss what is a public interest litigation when we will discuss Supreme Court. What is your litigation? What is your case? Sir, I want Supreme Court to issue directive to the central government that we should call this country only India, only Bharat, not India. The Supreme Court said, what rubbish. They're dismissing your petition. Don't come to us with these frivolous petitions, useless petitions. Come to us for solving the problems of corruption in the society, illiteracy in the society, lack of educational opportunities in this country. Don't come to us with these emotional issues. We cannot issue directive to the central government. Because Article 1 is clear, India, that is Bharat. Bharat, Atharth, India. Whether you call India or Bharat, that is your problem. But now something has happened. When the G20 summit was held in Delhi recently, the invitation from the president says, invitation from the president of Bharat. Mr. Modi went to Indonesia to attend the ASEAN India Summit. ASEAN is an organization of 10 countries known as Association of Southeast Asian Nations. And there he was referred to as the Prime Minister of Bharat. Now people saw that, is there any way or is there any objective that now the government wants to change the name of this country from India to Bharat? And they allege that maybe it is because the opposition bloc is known as the India bloc. Why? Because opposition political parties such as the Congress, such as the Communist Party, such as the Trinamool Congress, Samajwadi Party and others, Rashtriya Janata Dal, JDU, they have decided to come together and they call this bloc as India. And that is why the government wants that this name India should be removed. Instead, we should call this country Bharat. For that, we don't need constitutional amendment. India, that is Bharat, both are the official names of this country. So both can be used. But if you want to remove the name India, for that constitutional amendment is required. And you also need to tell United Nations that we have officially changed the name of our country from India to Bharat. So you have to apply before the nations, before the United Nations, that we have changed our name. Just like Turkey did recently. Turkey, they changed the name of their country. They petitioned, they sent a representation to United Nations that we have formally changed the name of our country, called as Turkey instead of Turkey. Same goes with India as well. If we want to drop the name India, for that we require a constitutional amendment. We have to amend the constitution. Otherwise, we can use both the terms, India as well as Bharat. But if we want United Nations to also refer to us only as Bharat, for that we have to give them a representation after we have officially changed the name of our country. But be that as it may, that's the political matter. Let's go back to the legal matter, the polity matter. Article 1 of the Constitution says, India, that is Bharat, shall be a union of states. We have two names for this country. Why? Because there was a lot of debate in the Constituent Assembly as to what would we call this newly independent country, India or Bharat or any other name. And ultimately it was a compromise was reached. Both are the names of this country. But India, that is Bharat, shall be a union of states. When we say union of states, let's go back to the discussion we had yesterday. A constitution can be a unitary constitution. Constitution can be a federal constitution. What is Indian constitution? If Indian constitution was federal, then Article 1, Clause 1 would have mentioned India, that is Bharat, shall be a federation of states. But since Article 1, Clause 1 says India, that is Bharat, shall be a union of states, that means Constitution accepts that we are a unitary constitution. But Dr. Ambedkar, he said India is a federal constitution. Also, somebody pointed out, Ravi Teja pointed out, President of India is mentioned, President of Bharat is not mentioned in the Constitution. You're absolutely right. Because only in Article 1, Clause 1 do we mention India, that is Bharat. In every other article, for example, Article 52, it says there shall be a President of India. So there can only be a President of India. Clear? Article 53 says all executive powers are vested in the President of India. But that is in the English version of the Constitution. What is in the Hindi version of the Constitution? Because that is also the authoritative text. Bharat ka Rashtrapati. That means both terms can be used. Okay. Dr. Ambedkar said ours is a federal constitution. But I have used the term union of states and not federation of states for two reasons. Which are these two reasons? Reason number one, India is not the result of an agreement between states no state has the right to secede from the Union of India. Article 1 to Article 4 comes under Part 1 of the Constitution known as Union and its territory. Clear? We have 28 states, we have 8 union territories. Union territories we will discuss separately in another chapter. Here we will talk about union and its territory, which talks about states only. Clear? Article 1, Clause 1, it says India, that is Bharat, shall be a union of states. And why India, that is Bharat? Now that is clear. India, that is Bharat, shall be a union of states. It gives us a sense that Constitution accepts that ours is a unitary constitution. Because if it was a federal constitution, then the term used would have been India, that is Bharat, shall be a federation of states. But since we use the term India, that is Bharat, shall be a union of states, that means we accept that ours is a unitary constitution. But Dr. Ambedkar disagrees. Dr. Ambedkar said, no, ours is a federal constitution. Ours is a federal polity. But I've used the term union of states and not federation of states for two reasons. Reason number one, India is not the result of an agreement between states. What does that mean? Which is the oldest federal constitution of the world? United States of America. On the world map, where is the United States of America? North America. Clear? This entire area was under the English occupation, was under the British Empire. Because Britain, France, these were the biggest colonizers of their time. Majority of the Asia, Africa, the Americas, they were under the control of these two empires. But be that as it may, there were these areas in North America which were under the control of the British Empire. And they were basically 13 British colonies. Was India a British colony? Yes. Similarly, in Northern America, there were 13 such colonies of the British Empire. And now these 13 British colonies, they decided to revolt against the British Empire. Why? Because they wanted independence. And that is what we call, which you will discuss and study in world history, American War for Independence. That means these 13 were the British colonies. Now they revolted, American War of Independence. They revolted against the British. Now these 13 British colonies liberated themselves, declared themselves free. Now these 13 British colonies, these are 13 independent sovereign countries. But these 13 countries, they now decide to come together. They say, why don't we come together and create a United States of America? But if we come together to create United States of America, what sort of government do we follow? What should be the role of individual state? What should be the powers of the individual state? And what should be the power of this new entity that we will be creating, the Union, the center of United States? For that, there were agreements. And ultimately, these 13 independent countries, which were previously British colonies, they decided to come together at Philadelphia. And they gave themselves a constitution in 1787. And this constitution got implemented in 1789, enacted in 1789. That means United States of America was not a political entity. There was no such thing as United States of America. United States of America was created, was born when there was an agreement. When these 13 colonies, previous colonies, ex-colonies, when these 13 independent countries decided to come together, enter into an agreement, and through that agreement was born a nation, a country, a state, an entity known as the United States of America. Dr. Ambedkar said, if I use the term India, that is Bharat, shall be a federation of states, it might get a sense that India as a political entity was created when these states decided to enter into an agreement to create India. It didn't happen. India was already there. But Dr. Ambedkar, there were 562 princely states. When you look at the colonial period, during the British period, there was India, but then there were princely states as well, those were away from India, away in the sense they were out of the fold of India. Princely states such as, which were ruled by the princes, for example, Hyderabad, for example, Baroda, for example, Mysore, for example, Jammu and Kashmir, for example, Patiala, so many princely states. These princely states joined India. So can we not say that there was an agreement through which these princely states joined India? Should we not then call India as a federation of states? Dr. Ambedkar said there is a difference. When these 13 colonies declared independence, they decided to come together, enter into a treaty, enter into an agreement to create United States of America. So through that agreement, they created USA. India was already there. It was not created. India was already there. And now these princely states, they have the option of joining India, merging with India. That is why I will use the term Union of States so that people are not confused. That India is because an agreement was signed to create India by these states. So India is not the result of an agreement between states. And number two, no state has the right to secede, to come out of the Union of India. You and me have a treaty. You and me have an agreement. Or let's say the 10 of us have an agreement. After 10 years, I will say, I'm coming out of this agreement. I'm seceding from this agreement. I'm breaking away from this group. It's possible. So in a federation, if it was because of an agreement, it may also mean that at one point in time, one state, they will come out of the arrangement. They will back out of this treaty. That is something that we will not allow in India. In India, no state can come out of the Union of India. This country has to be integral. That is why I have used the phrase India, that is Bharat, shall be a union of states. Which means there are two names to this country, India and Bharat. And we call this country Union of States and not Federation of States. That doesn't mean we are not a federal polity. We are not a federal constitution. Our constitution is federal. But we've used the term Union of States for two reasons. Because one, India is not the result of an agreement between states, and no state has the right to come out, to secede from the Union of India. Is that clear? And this term, India, that is Bharat, shall be a union of states, excludes union territories. Excludes union territories. Why? Because what is federal polity? In federal constitution, there are some characteristics. What are the characteristics? Dual government. One government at the center, one government at the state. Distribution of powers. Some powers given to the center, some powers given to the states. Schedule 7 of the constitution, something we discussed yesterday. This federal relationship, union shares only with the 28 states that we have. Because in 28 states, we have dual government. We have distribution of powers. Union territories are directly under the control of the center. In Lakshadweep, there is no chief minister, there is no legislative assembly, there is no dual government, there is no distribution of power. Center makes laws for Lakshadweep. Center makes laws for Ladakh. Center makes laws for Andaman and Nicobar Islands. Center makes laws for Chandigarh. Yes, there are exceptions. Exceptions such as Delhi, exceptions such as Puducherry, exceptions such as Jammu and Kashmir. But that is something that we will discuss in a separate chapter known as union territories. But here, just keep in mind, India, that is Bharat, shall be a union of states. And this phrase states, this term states, does not include union territories, because union territories, because they don't share federal relationship with the union. Because they don't share federal relationship with the union, because there is no distribution of powers, there is no dual government. That is why union territories are separate. But in Indian states are integrated by agreements. Okay, so there is one question by Anju, and the subject matter expert has given a wrong answer, which I would like to flag. Anju says, sir, but Indian states are integrated by agreements like instrument of accession. Then how can we say there is no agreement between the states? And the answer given by the subject matter expert is that instrument of accession related to Kashmir only, which is not true. Every princely state which joined India signed the instrument of accession. Every princely state, whether it is Baroda, whether it is Hyderabad, whether it is Junagadh, whether it is Patiala, every princely state which joined Union of India signed this instrument of accession. But India was already there. India was not created through this agreement. They only joined India. That is why we do not use the term federation of states. Is that clear? So the term India is not covering UTs. My dear, the term states here does not cover UTs. India includes union territories. So doesn't Bharat ka Rashtrapati in Hindi constitution is gender biased? Yes, but look at the entire constitution. He, she is never used. Look at the laws that have been passed. He. So by that logic, we are all patriarchal. Okay. Article 1, Clause 2. We are still discussing Article 1. And in Article 1, we have 3 clauses. Article 1, Clause 1, which says India, that is Bharat, shall be a union of states. Article 1, Clause 2, which says the states and territories thereof shall be specified in the first schedule. What is a schedule? It's an explanatory memorandum of an article. If an article requires more explanation, we add this explanation at the end of the constitution in the form of a schedule. Why? The names of the states and territories thereof. If instead of first schedule, we had to mention the names of all the states and territories here, then Article 1 Clause 2 would have said we have to specify 28 states and the names of 8 union territories and their territory as well. That means they are spread as well. We had to mention in Article 1 Clause 2 itself, which would mean that Article 1 Clause 2 would become very bulky, would become very lengthy, because lots and lots of details are there. To prevent this from happening, if an article requires more explanation, instead of adding this explanation in the text of that article itself, we add this explanation in the form of a schedule at the end of the Constitution. Schedules are part of the Constitution, but these are explanatory memorandum of an article. Article 1, Clause 2. The names of states and territories thereof shall be specified in the first schedule. If this first schedule was not there, then this article would have read, the states and territories thereof are specified below. And below we will have to mention 28 states, 8 union territories and their areas. So this entire article would become very bulky. Maybe the members of the Constituent Assembly thought, even then, that lean is in. We should have as shorter, as crisper articles as possible. If an article requires more explanation, we will add the explanation at the end of the Constitution in the form of a schedule. For example, this is the first schedule. Jammu and Kashmir. What is the territory of Jammu and Kashmir? What is the territory of Nagaland? What is the territory of Haryana, Himachal Pradesh, Manipur? All these details are mentioned in the first schedule of the Constitution. So Article 1 says, number 1, Article 1, Clause 1, India, that is Bharat, shall be a union of states. Article 1, Clause 2, the states and territories thereof shall be specified in the first schedule. That means we have 12 schedules. First schedule we have now encountered. That means the names of the states as well as union territories is mentioned where? Is mentioned in the first schedule of the Constitution. Why not in the article itself? Because then article would become very bulky and then lean is not in. That is why we have added the explanation towards the end in the form of a schedule. Clear? Sir, once again explain indestructible union of destructible states. I can't explain it once more because I did not even explain it once. I will explain it tomorrow when we will discuss Article 3 of the Constitution. Why we apply at UN for changing a name of our own country? Not changing the name of our country. We change the name of our country on our own. But then you have to inform somebody. It's like, I have changed my name. Why should I inform the college authorities I've changed my name? Because the certificate has to change. On the certificate, the name has to change. So you can't be arrogant. No, I have changed my name. I will not tell anybody. I don't need anybody's permission. It's not about permission. You change your name. Nobody can stop you from changing your name. But then how do you want others to call you? You have to inform them. So that is only a formal process. Can we change the name of our country now? Can? Yes. Why not? What is the legal age of contesting election? If you want to contest Lok Sabha election, 25, Assembly election, 25, Rajya Sabha election, 30, President's election, 35. Does changing name India into Bharat need constitutional amendment? India, that is Bharat. It's clear. Both can be used. But if you want to remove India and keep only Bharat, it requires a constitutional amendment. But maybe then Supreme Court will say, even the name India is part of the basic structure of the Constitution. So you can't even change the name of this country. Or you can't even use only Bharat and not India. Panchayat elections are not conducted by Election Commission. Panchayat elections are conducted by State Election Commission. And we will discuss that in Panchayats. Sir, how about changing it to Hindustan? Nobody is asking it to be changed to Hindustan. So why do you want it to be changed to Hindustan? Sir, please take my question. Organizing the Kumbh Mela by Government of India is against the spirit of secularism. Please tell. No, it's not against the spirit of secularism. The government is not organizing Kumbh Mela. The government is facilitating Kumbh Mela. Just like the government is facilitating pilgrimage to Hajj or pilgrimage to other sacred cities. While campaigning for elections, politicians talk in favor of one religion. Is it not violating secular India? It is, but they cleverly word it in such a manner that it is not violative of anything. Because in 1998, a judgment was given by the court, by the Supreme Court. The Chief Justice was Justice J.S. Verma. The judgment was Manohar Joshi versus Election Commission of India. Supreme Court said Hindutva is not a religion. Hindutva is the way of life. So if somebody is asking for votes in the name of Hindutva, it is not violative of secularism, it is not violation of the Representation of the People Act. Okay, that is it for today. We will meet again tomorrow, 6 o'clock in the morning. We will discuss Article 1 in its entirety. Then we will complete Union and its territory chapter. And hopefully we will get to start citizenship as well. Please don't miss tomorrow's lecture. See you tomorrow, 6 o'clock in the morning. Till then, have a great time. Bye-bye. Stay safe.